Hi everyone, I'm Gracie Peck. I'm the Instructional Design Manager over at RAR. So today I'm here with legal counsel Michael Lafayette. Now the current coronavirus, also known as COVID-19 pandemic, is impacting real estate and transactions across this country and right here at home. So working with the CVR MLS Standard Forms Committee, Michael has developed 3 new forms for us to use with the CVR MLS Purchase Agreement. Now these forms, they address settlement delays that are related to COVID-19 and conditions that could affect buyers and sellers, lenders, and settlement agents. So there are 3 forms: the COVID-19 Addendum, the Notice of Quarantine, and the Notice to Proceed to Settlement. Now these have all been approved by the CVR MLS Board of Directors, and they're available for immediate use on our website. Now that's at rarealtors.com/COVID-19, no dashes, COVID-19. Now these will be available on Instinet by close of business on Monday, March 23rd. This video is recorded on Thursday, March 19th, just to keep that in mind as information updates. So I'm going to introduce Michael Lafayette, who wrote the forms and will be able to answer your questions. Hi, Michael.
Hello.
So, Michael, before we discuss the form specifically, I would like you to address several broader questions, such as, what is your general advice to agents at this time?
I think it's really important that agents understand to set the expectations with their client. It is absolutely important that clients understand the situation that we're in. And there are a couple of things to keep in mind. First of all, that this is a temporary something temporary in nature. So in other words, it is going to get better, whether it's weeks or months, but it is a temporary situation. So one, just understand that it is temporary. But number 2 is, most importantly, patience. Patience is what is needed in a transaction, particularly when we know that transactions will be delayed, and there will be different, perhaps like bumps or different things that will occur during the transaction that will cause some frustration. So patience is certainly very much needed for this. But I think most importantly is, in addition to patience, of course, is working as a team. You need to make sure that everyone is on the same page. That is your closing attorney, the lender, your clients, agents on the other side. Everyone has to work together as a team to get through this. And while that may seem pretty elementary, it is really important. One of the first things that is important as working with a team is not only informing your client that closings can be delayed, but unfortunately, some of these components are outside our control. So even though you have a great team, things are outside our control. For instance, courthouses are closing or have restricted hours, and it seems like the hours of operations between a courthouse seems to be changing day to day or almost hour by hour. So right now, we're very fortunate in the Richmond market that the courthouses are open for at least e-recordings, and that's electronic recordings. So that means that documents can be filed electronically at the clerk's office and recorded. Also means that title searches can be done to a limited extent because the electronic records are open. So it's pretty important to know on the team, are you using a settlement agent that has e-recording capability? Do you have title companies that have electronic communications with the courthouses, so that way title searches can be done? So there's just a lot of things that can be done, that should be done, and then working as a team is really important. But it all comes back to set expectations with your client. Let them know that even though you're working with a great team and everyone's trying to accomplish a settlement, there will be delays because a lot of these things are outside our control, particularly courthouse closings.
Thank you. And then I guess first off, a big question that we're receiving along with others is, what exactly is settlement and how does settlement and possession relate to recordation?
Okay, that's a great question. So let's just talk what the definition of settlement is. Settlement in Virginia is when the deed is delivered to the settlement agent. The settlement agent also receives all the funds in the transaction. That can be the funds from the purchaser, or if there's a lender, the lender also, and that all conditions of the transaction have been met. So again, we have the deed, we have the funds, we have the loan documents, and then all conditions have been met. Once all those documents have been signed off on and all conditions are met, settlement is complete. That's it. So recordation of the deed is not part of the settlement process. It happens after settlement. So there's been questions about, well, what happens if we have settlement and the deed is delayed from recordation? Well, that's a separate function. So for purposes of settlement, settlement again is when the deed is delivered, all funds are received, any loan documents signed, and any documents at all that have to be signed, and that would then complete settlement itself. Recordation is a whole separate function. Recordation just means putting that deed and maybe loan documents to record in the public venue, and that is at our circuit courts. So if you settle today, have a settlement today, do a closing, and it records tomorrow, then a normal disbursement would happen. There are some courthouses that are slightly delayed right now, so that you may close today, and it may be a day or a couple days in which recordation occurs. It doesn't mean that settlement hasn't occurred. It has. Settlement's done, it's closed. It's just that the recordation is delayed. And if a recordation is delayed, so will be the disbursement of funds to the seller.
And then who is even responsible for any additional expense to either the buyer or the seller related to a delay in settlement?
So right now, as the contract exists, our purchase agreement exists, the cost of delays are borne by each party. And right now, it is just a matter of, it's unfortunate, but there are going to probably be expenses on both sides. I understand sometimes sellers are upset that a delay may be causing them to pay extra expense on their mortgage. But on the flip side, you also have the buyer who perhaps has to pay additional costs to their lender to extend a rate or other things like that. So unfortunately, both sides are suffering, and both sides or either side would pay their own cost if a closing is delayed. The only way to change that would be to do an addendum, a separate addendum, and that would shift the cost of any particular extension from one party to the other party. That is not part of our COVID-19 addendum. So right now, as it stands, even use of the addendum that we're going to go over in a minute, costs would just be paid by the respective party who has that cost.
And can funds be dispersed if recordation is delayed?
Funds typically are not delayed until after recordation occurs, and that is because in order to have recordation, a mini title search has to happen to make sure that there's no intervening liens from the seller from the time of closing to the time of recordation. Because if there's a lien, for instance, if someone didn't pay a bill or there was additional money withdrawn or from a credit line, anything like that, that would then be a lien on the property. So it's really important that the buyers have good title, and before we disperse any funds to the seller, we want to make sure that the title is checked, and that's what we call the rundown, or at the time of recordation. So if settlement happens today, closing happens today, and recordation doesn't happen for a day or two, then we're not going to release the funds. Virginia law is also very clear that it should be 2 business days. So from the time of settlement to the time of recordation and disbursement, it's supposed to be done in 2 business days. But we're in some different times right now with the state of emergency and some other declarations that have been put out by the state and federal governments. If the courthouses are closed and things can't get done, then automatically that time period would be extended. So for instance, if you closed on a Monday, but the courthouses were closed Tuesday, Wednesday, Thursday, then I still think you have 2 business days in which to do the recordation and then disbursement. So understand that the seller could be upset that perhaps they're waiting several days to get a disbursement, but recordation really needs to happen in order for a disbursement. We just really need to make sure that the title is clear.
So what advice should listing and buyer agents be giving their clients concerning possible settlement delays?
Well, there are a couple things that come to mind with respect to delays that may happen with settlement. First of all, if you're representing a seller, I think it's very important that the seller understands that closing can be delayed due to factors outside the control of the purchaser. For instance, as we talked about for the first few minutes here, closing of a courthouse really affects the closing itself because no recordation can occur. If there's no recordation of the deed, then you can't have a disbursement of funds. So sellers just have to understand that, hey, if the courthouse is closed, they're probably not going to get their funds until the courthouse opens up. There are some indemnification agreements that are now being circulated by the title companies. They've really come out in the last couple of days. And let me explain what an indemnification agreement is. It's basically an agreement that says buyer and sellers agree that if recordation can't happen, then perhaps they can go ahead and do a disbursement of the funds. But if there's anything that's recorded at the courthouse that would be a lien on the property, then the parties are liable to the title company if title is not clear. I think that's a dangerous precedent to set, and I do not recommend, and most attorneys that I've spoken with do not recommend that clients sign these type of indemnification agreements, because really what that means is it's a blank check. It's an open-ended contract that says, hey, just in exchange for me getting back my funds, I'm going to indemnify the title company if there's any issues with the title. I think if there's a change in circumstances with the courthouses where that they're closed for an indefinite time, then closings should just not happen. Right now, again, we're very fortunate that the courthouses are open, and are accepting e-recordings, and so things are going pretty smoothly. As you mentioned, today is Thursday, the 19th, and all week we've had a little bit of confusion and a little bit of misinformation, but we have been able to record documents in all jurisdictions except Chesterfield all week, but even Chesterfield reopened today for filing. So right now in the metro area, as far as I know, as this date, everything is open and functioning and recordings are happening, and that is what we hope will continue to happen. So closing should continue to happen as of this point. But again, if a courthouse is closed for an indefinite time period, I'm not talking 1 or 2 days, but if they close indefinitely, I would caution you on having or recommending that your client sign an indemnification agreement that says they're liable just to get their funds. They really need to talk to their closing attorney and be explained what those ramifications are. I just don't think they're worth the risk.
So we'll move on to the forms themselves. So first I want to talk to the first form, which is the actual COVID-19 Addendum. So for our members who are watching now, if you go to rarealtors.com/COVID-19, that was the website I referenced earlier, this is where we have our updates. Right now we have our forms here. So you'll see the 3 forms, 180, 181, 182. So these 3 forms are available until they are in Instinet on Monday, March 23rd. So what you have on your screen now, this is the COVID-19 Addendum. So can you give us, Michael, a quick overview of this form?
Sure. So this is an addendum like any other addendum. So at the top of the form, you would insert the information, the buyer-seller information, date of the original purchase agreement, location of the property, etc. So all that is very straightforward on the beginning of the first paragraph. As far as paragraph number 1, which is actually the substance of the addendum, what this just sets out is a time frame. Basically, what the COVID-19 addendum is trying to do is to recognize that there's probably going to be delays if there's a quarantine or if there's a closure, say, of the courthouses or, say, like the lender. So with paragraph number 1, what it sets up to do is that if a party or their settlement agent or their lender becomes the subject of a voluntary or mandatory quarantine or closure, then the party who's affected can give notice to the other party saying, hey, unfortunately, we have a quarantine situation or we have a voluntary or mandatory closure, and so therefore we're putting you on notice. At that point, settlement is delayed, and it's delayed until 5 days after that quarantine or closure is completed. So when that happens, then a second notice would be given. So as part of this addendum, there are actually 2 accompanying forms. So with that first paragraph, if you become the subject of a quarantine or you become the subject of a closure that's related to your transaction and the client has to give notice, there's a specific form, and that form is called Notice of Quarantine or Closure regarding COVID-19. And you would complete that form, have your client complete that form, sign off on that form. And for instance, if you were representing the purchaser and it's the purchaser who is actually affected, then you would obviously give notice to the seller. You would indicate in that notice the reason for the extension that is needed for settlement, and then sign off on it by your client. In that case, my example was the purchaser, and you would provide it to the seller. So that would give notice that there is a continuation or an extension of time for settlement. Now, it's really important to understand that with our addendum, there is not a right of termination. It was clearly discussed among the Standard Forms Committee, who are members of the RAR community, members like yourself, and everyone thought it was very important to understand that this is a delay, but it is not a right for someone to walk away. In other words, not a right for someone to terminate the contract. We just want to use the the time to just kind of delay the settlement, but not to terminate the settlement. So it is simply a delay on settlement. Paragraph 2 of the COVID-19 Addendum is just an acknowledgement that in addition to a person being affected, it also could be that the clerk's office is closed and that recordation could not occur. In that case, settlement may also be delayed because if the courthouse is closed, then you can't get a title search done and you can't perhaps even get recordation done. So the settlement may be delayed because of that. So if you see in paragraph 2 there, it was talking about delays due to the courthouse closure or recordation. And then also it could be that the settlement occurs, but because maybe it's just a delay or a partial closure, the recordation of the deed is delayed. So in that particular case, settlement has occurred, which is great, but the recordation is delayed and therefore the disbursement of seller's funds may be delayed. So it's just putting the parties on notice that may occur. As I said at the beginning of this cast, it's really important to set expectations with your particular client. So if you're representing a seller, let them know you're working as best as you can to ensure that everyone wants to get to settlement, but disbursement of funds may be delayed. And of course, if you're working with a purchaser, they also have to have patience that may not be able to move in or have a settlement because there may be some delays of settlement. You'll see in paragraph 3 of the COVID-19 that there's also some definitions, understanding that the word day or days means a calendar day. It doesn't mean any type of business day. It's a calendar day. And written notice can be delivered by in person, by personal delivery or by email, certainly by Authenticign or fax, any kind of electronic transmission. So I just talked about the first notice, which is the notice regarding the quarantine or closure, and there's a second notice. Once that is completed, so once the quarantine is over or the closure that affected the affected party is concluded, then you should go ahead and send notice to the other party that the quarantine is over or the closure is over, and then that they're proceeding to settlement. So it's a simple form to fill out, check out the box or check the boxes that are appropriate and send it on to the other side. Make sure that the affected party is signing these notices and sending them over to the other side. We purposely have included these notice forms because this way it provides a nice document trail of what is exactly happening in the transaction. I would like to also add that in the event that there's any additional terms the parties want to include, paragraph 4 of COVID-19 does allow for the insertion of additional terms, anything that is negotiated between the buyer or the seller.
Now, is this addendum required for all transactions?
This addendum is not required for all transactions. This addendum is voluntary. It is just to address concerns of some parties when it comes to quarantine or closure. So it is not required, nor is it mandated. So of course, CVR MLS can't mandate the type of forms to be used, but it is recommended because we do believe in the coming weeks and maybe even months, there will be closures, there will be quarantines, and delays are likely. So it's really important, I think, to put the parties on notice that, hey, we're working together, but delays probably will occur, and this addendum provides a mechanism in which a delay can then be used. If someone refuses to sign the addendum, there's nothing you can do. It can be offered on one side, and if the other side says they don't want to sign it, you can't force them to sign it. But I do recommend highly that it be used in transactions until the COVID-19 is no longer a factor in our marketplace.
And you touched on this a little bit, but when should listing and buyer agents use this form?
They should use this form, I think, in current transactions that are pending that are not scheduled to close in the next couple of days. They're perhaps weeks or more than a month away because it is likely that there could be some effect to that closing. So I think now's the time to even add the addendum to that transaction. Again, as I mentioned, a party does not have to sign this. So if a purchaser or seller says, no, I'm not going to sign this, there's nothing you can do, but you should recommend it. I think it is a good process. I think it's very straightforward, deals with how to handle a delay and what's reasonable. And I think it's very straightforward. So you can recommend it, but again, you can't force it. If it is a new contract that you're about to enter into, so you're just filling out now the new purchase agreement between now and the next several weeks or even months with transactions where the COVID-19 is still among us, then it should be, in my opinion, attached to every single transaction.
And you touched on this a little bit, but like you said, buyers or sellers may be unwilling to sign the addendum. What do you recommend for realtors when that situation arises?
If a buyer or seller is unwilling to sign the COVID-19 addendum, just advise them that then there is no mechanism to work out a delay, and so that would be unfortunate. What a buyer or seller may think is that they may have the upper hand by not signing one of these addendums, but they may end up being the one who needs it. They could end up being the affected party. They could be the one whose lender is not available for a loan package, or the courthouse closes. Or if it's on the seller side, seller just wants to close, they want their money fast, and they're afraid to sign an addendum, thinking that they are helping themselves by not signing the addendum. But then the seller could become the party of the affected party. Closing is delayed, and then suddenly the purchaser is asserting that they're in breach of contract. So, it can work both ways. It can help or hurt in some ways. I think is what a party is going to look at. Overall, I think it helps, because we don't know who could be affected by a quarantine or who could be affected by a closure. And that's what you need to remind your clients, that you don't know who could be affected. This very well could assist them, and it's unlikely to hurt them.
So should agents go to their respective clients who are currently under contract, and this isn't really top of mind for them, but recommend that they execute this addendum?
I think any transactions that are pending right now that are due to close in the next several days or into the next week, I don't think the addendum is necessary at this point, because it should be on track to close. That's assuming lenders are geared up, courthouses remain open. I think if you have a transaction that is a few weeks or longer out there, then I do think it's smart to go to your client and say, hey, here's a new addendum. This is just in case something were to come up with a quarantine or closure. This is just a good business practice, a best practice to understand and to deal with the situation. So yeah, if it's, to me, if it's more than a week out, you probably want an addendum signed. That way you have a procedure in place in the event of a quarantine or closure.
And I'll bring it back to the form itself. And as you see in paragraph 1, for those of you following along, there is a 30-day extension limit indicated in this first paragraph. Now, Michael, is that something that can be changed?
Yeah, so the timeframes in the form can be changed. So first of all, even the first one, which is the 5 days, that closing will occur 5 days after the conclusion of the quarantine or the closure. That can also be adjusted. You can make that shorter or longer. So that's certainly something that is negotiable. That is not a state statute. That's not a regulation. That is just what the Standard Forms Committee believed to be a good period of time. And as to your question, as to 30 days, that also can be changed. So there are some folks that perhaps would like a shorter time period. Some would like an extended time period. We chose 30 days because we thought that was the most reasonable given the facts and circumstances that we know. So absolutely can be changed.
So with this COVID-19 addendum, you did discuss how there are also the notice of quarantine, as you all see on the screen now, and this notice of notice to proceed to settlement. What should they know specifically about these notices with this addendum?
So we provided notices because we thought it was best to have a written format for agents to use, so that way there's consistency in the marketplace. So starting with the first notice, the notice of quarantine or closure, that is just putting the other side on notice that there is a quarantine or closure, and it's very straightforward. So again, it's just putting in place a standard format notice, so that way the affected party can notify the other party to the transaction. So that one, again, is very straightforward. You just check box what has to happen. It is important, though, in the second one. So once that quarantine or closure is over, then the parties are required per the addendum to move forward to settlement within 5 days. So you do want to make sure that the transaction is moving forward. Everyone wants to close. Everyone wants to go and get everything concluded. So once the quarantine or closure is over, be sure, if you're representing the affected party, that you do complete the notice and you send it to the other side, so that way they're on notice that the transaction is moving forward. I also would note that the 30-day period, going back to the COVID-19 addendum, does say 30 days or unless mutually agreed upon, different dates agreed upon. There's nothing stopping the parties from separately doing another addendum or doing an agreement to extend that 30 days. God forbid someone does get quarantined because they have the virus and they need more than the 30 days. And then the parties can certainly agree to extend that, and that would be reasonable. I think thinking a party, for instance, like a seller or purchaser who has the COVID-19 and they just are not over the symptoms yet and the 30 days has expired, well, that makes no sense to try to say, oh, we're going to force them to closing or we're going to make them to be in default. You got to let time. We all have to have patience. We all have to be reasonable, and we all have to understand it. We'll get to closing, but we may have to extend that time even more.
So those are all the questions that I have regarding these forms and this overall process. Is there anything else that you would like realtors to know?
Yes, I just like to reiterate what I said at the very beginning, which is please set expectations with your clients. Those expectations are that we're all working very hard, very diligently to ensure that transactions move forward, but it is going to take patience on behalf of everyone. That's both members, so agents, and also their clients. And understanding that a lot of factors that are happening now are outside of our control. We cannot control the courthouses when they open and close. We cannot control whether or not a lender is open or closed. So there's a lot of these factors or components that are involved in the settlement that we can't control. Nevertheless, everyone is working very hard, long hours. Most people are working overtime, just trying to put everything together so that settlements would proceed forward. So again, I just reiterate, set those expectations with your clients that everyone's working as a team, but delay is probably going to happen. Delays will happen, and that closing dates or even disbursement of funds. But ultimately, we should get over this and then get back to a normal market. But in the interim, it is going to be a little bumpy, but we'll get through it.
Michael, thank you so much for taking the time to talk to me and all of us here today. I just want to reiterate very quickly, rarealtors.com/COVID-19. That is your source for information and updates from the association and the MLS regarding COVID-19. If you have any questions about something that we covered here today, you can reach out to us via email. We will be staying there even through any kind of chaos that may be coming. Membership@rarealtors.com. You can reach us and we will make sure your question goes to the best person who is suited to answer that. I really appreciate all of you who are doing your best and your due diligence to serve your clients during this difficult time.